Were you using any fireworks?
Yes, I was.
And did one of the fireworks that you ignited land on the victim's property?
Yes.
All right, Ms. Hernandez, thank you. So this is in the matter of the people of the state of Michigan versus Yesenia Hernandez, file number 25-22280FH. I have Manny Kavajian appearing on behalf of Ms. Hernandez, and I have Douglas Hartung appearing on behalf of the people. What is this? This might be an arraignment. Let me check.
It's a pretrial.
Oh, it's just a pretrial. So, Mr. Kavajian and Mr. Hartung, how would we like to proceed?
We did have a discussion previously about doing a universal plea deal with her misdemeanor and the felony, wherein the misdemeanor was reduced to disorderly, which we already took care of that one, and then this case was supposed to be resolved with the plea deal pursuant to HYTA. So if that's what we're still doing, I think we're going to be moving forward with that.
That's accurate. On the information, there is a count two. I guess it was added at the time that she was brought upstairs after she waived exam. She would enter a guilty plea to count two. We would have no objection to the HYTA program for Ms. Hernandez. And there would be some restitution that would be determined by the court.
What was count two?
Arson, third degree.
And count one is dropped?
Count one is dropped.
Yeah,
Okay,
count one is second degree arson, which is a 20-year felony, so that would be dismissed. Count two is third degree arson, carries a maximum penalty of up to 10 years and $20,000 fine or 3 times the value, and that's eligible for HYTA?
I believe so.
Okay, he believes it, and I mispronounced your first name, it's Monty, but he said it's eligible for HYTA. So as long as she's eligible for HYTA, there shouldn't be a problem. So is that your understanding of the plea, Mr. Kavajian?
It is, Judge. Would your honor be willing to do a cops to HYTA?
If he has no objection to it, then I will do it as long as she's eligible.
Yeah, that's the plan.
Excellent. I'd really appreciate that.
So that's basically a Killebrew more than a cops. So, does your client wish to avail herself of that today? You want a breakout room with her, or?
Yeah, but we could briefly. I just want to explain to her what all that means, but that was our aim. It was to follow through with that, Judge.
Okay, so I'm gonna pop the two of you into a breakout room. Ms. Hernandez, just click join the breakout room. If you can't figure out how to get out of there, don't worry. When your attorney comes back, I will bring you back. So let me find you. There you are. Right, go ahead and join that breakout room. All right, so we got Ms. Hernandez back. So, Mr. Kavajian, how would you like to proceed?
Judge, we'd like to move forward. The only addition I would have is that we would like to tender a plea of no contest rather than a guilty plea to avoid civil liability.
Would that be all right, Mr. Hartung?
Well, the
Oh, I can't do a no contest for HYTA.
not for HYTA, and also there's a restitution issue, but I think the plan was to have her plead guilty.
I can't do no contest because HYTA has to be a guilty.
Gotcha. Ms. Hernandez, do you understand that, what we're talking about, the difference between the no contest and the guilty plea?
Yes,
Do you want a breakout room with her to talk through what she needs to say, or you good?
I think we're okay, Ms. Hernandez. Are we okay, or do you want to go back in the breakout room so we can talk again?
Yeah, just real quick, please.
Okay, sure.
Okay. All right, so let's go. And... All right, so we are back with Ms. Hernandez. So I have a note, by the way, from Darren Coast, my pretrial services coordinator, that says she currently has a GPS tether on. She has been compliant and there have been no violation notices. So my understanding is she would plead guilty to count 2, third degree arson, and if eligible, she would be sentenced under the Holmes Youthful Trainee Act. So is that what your client wishes to do, Mr. Kavajian?
It is, Judge, and then we would also like a moment to address bond, if we could.
Okay, can we do that after the plea?
Whatever's your preference, Judge.
Okay, is that a correct recitation of the plea then, Mr. Hartung?
Yes, Your Honor. Count one in the habitual offender charge will be dismissed as sentencing.
Okay, all right, so Ms. Hernandez, do you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, can you state your full name for the record again?
Yesenia Hernandez.
All right, so Ms. Hernandez, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 2 third-degree arson, which carries a maximum penalty of up to 10 years in prison and or a $20,000 fine, or 3 times the value of the property damaged or destroyed, whichever is greater? So is it your intention to plead guilty to that charge?
Yes, it is.
You understand, as long as you are eligible, you will be sentenced under the Holmes Youthful Trainee Act.
Yes.
Okay, and are you satisfied with your attorney and the advice that he has given you? All
Yes, I am.
right, so ma'am, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Hartung?
Yes, Your Honor.
Mr. Kavajian?
Correct.
And Ms. Hernandez?
Correct.
Other than what was put on the record. Okay. So if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, ma'am?
Yes, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, I do.
Do you understand that if the plea is accepted and you engage in any misconduct defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the term of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentencing. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Ma'am, do you have any questions about the rights that I've given to you?
No, I do not.
All right, so how do you wish to plead to the charge that on or about July 7 of 2024 in the city of Adrian in the county of Lenawee that you did commit the offense listed under count 2, third-degree arson? Guilty or not guilty?
Guilty.
Okay, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea agreement to induce, or the plea bargain to induce the defendant to plead guilty? Mr. Hartung?
No, Your Honor.
Mr. Kavajian?
None, Judge.
All right, so other than the plea agreement that was placed on the record, ma'am, has your attorney promised you any other particular sentence or estimated what your sentence will be in terms of probation, fines and costs, incarceration?
No.
All right, is it your own choice to plead guilty?
Yes, it is.
All right, so ma'am, on July 7 of 2024, were you in the city of Adrian in the county of Lenawee?
Yes.
And so Mr. Kavajian, if you wish to voir dire, I don't know if it was started a fire or an explosive device. Perhaps you can ask her the questions for what happened that day.
Sure, Judge. On the date in question, were you using any fireworks?
Yes, I was.
And did one of the fireworks that you ignited land on the victim's property?
Yes.
And did it ignite a fire?
Yes.
Judge, is the court satisfied?
Mr. Hartung might have a few questions about intent.
Counsel, also, okay, may I ask a couple questions? Fine, is that all right?
Absolutely.
Okay. Ms. Hernandez, the property that was ultimately burned by your throwing of was it you threw a firework onto this property? Is that fair to say it that way?
Yes.
And do you remember what type of firework it was?
I don't.
The police report indicated that it was a red rhino, colorful dream fountain type of firework. Does that ring a bell with you?
I honestly don't remember because I was intoxicated at the time.
Okay. You were told later by the police that your fingerprints did appear on the paperwork for that firework that was thrown. You understand
Yes.
that?
Yes, 7
Okay.
months later.
Correct. And the person whose house was damaged, you did not know the individual who owned that house. Is that correct?
No, I did.
No, I'm not talking about the tenant. I'm talking about the owner of the house. Did you know the owner?
Of the house?
Yes.
Yeah. Yes, I did.
How did you know the owner?
We used to be in a relationship together.
Okay, that would have been one of the tenants of the house, correct? One of the
So
people.
ma'am, do you understand that was a rental property and there's an owner and then the
Oh.
person who was
Oh, okay.
renting?
Then no, I do not. Sorry.
Okay, thank you.
You did not know the owner, but you did know some people that were living inside the property, correct?
Correct.
And one of those was a person you had a previous romantic relationship with.
Correct.
And where were you at in relation to the entryway of that property when you threw the firework?
On the stairs.
Okay, was it your intention to throw the firework inside the property?
Yes.
And you understand that when you did this, the firework, you had lit the firework before you threw it, is that correct?
Yes.
And the firework ignited inside the entryway or foyer to the house, causing some damage to the carpet and rugs and footwear that was in that area. You understand that?
Yes.
I have no further questions. Thank you.
All right, thank you. Has court complied with MCR 6.302 B, C, and D? Mr. Hartung,
I believe it has, Your Honor.
Mr. Kavajian?
Absolutely, Judge.
All right, accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. There is a Killebrew agreement between the prosecutor's office and defense counsel, and the court will, of course, as long as there's no violations, honor that plea agreement or Killebrew agreement. But other than that, the court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I will address bond just in one moment. I'm going to refer the matter to the probation department for a pre-sentence investigation. Mr. Kavajian, are you available September 5 at 8:15? Well, first I need to ask, Mr. Hartung, do you wish sentencing to be in person or via Zoom?
It can be by Zoom.
It can be by Zoom. So Mr. Kavajian, Ms. Hernandez, you have a right to come in person and stand in the courtroom, right? But you can also appear via Zoom. So I'm going to leave that choice up to you. Do you want to appear in person or via Zoom?
Zoom would be better. That way I don't have to miss work.
Okay. So Mr. Kavajian, that being said, are you available September 5 at 8:15 in the morning?
Absolutely, Judge.
All right. So I'm going to set this for September 5 at 8:15 in the morning via Zoom. So ma'am, when we're done here in a minute, I'm gonna put you in a breakout room with the Michigan Department of Corrections Probation Department, your attorney can go to. And when you speak with them, they're gonna give you some instructions, a packet to fill out, instructions, as well as a time to come meet with them. When you do meet with them, be truthful with them about your background and the events that occurred. They'll prepare a pre-sentence report. We will get that to your attorney. Your attorney will review that with you before the day of sentencing, and then we will see you back on that day. Mr. Kavajian, do you wish to address bond now?
I would, Judge, please.
Go ahead.
As the probation department already notified you, she's been in compliance with everything that's been required of her, in compliance with the tethered requirements. She is a single mom, Judge. She is working at Motel 6. Her child does have some medical issues for which she is requesting permission to travel. I believe it's to the state of Ohio. And then she does also have travel requests due to her employment that I believe she needs to go to the state of Texas. So we were hoping that the court would allow her for permission to travel while on bond, and later, as long as everything's good on bond, extend that throughout probation if she needs to travel for medical or employment. And we would also ask Judge if the court would allow her to remove the tether. It is rather pricey for a single mom, and she has been in full compliance, and she wants nothing to do with her ex. She's not seeking any contact with him. So I kind of don't really see the need for it. I could definitely see the need for it when we first started this case, but where we're at now, her need to move on, her desire to move on, her want to never see this man ever again, coupled with the fact that she's got a lot to lose here. You're gracious enough to give her that HYTA deal. If she were to violate bond, she understands that HYTA is not going to be in her future. And I think that carries, a big, big carrot with it. And with that carrot, with that benefit, I think we could maybe, lessen the leash a little bit and understand that she's not going to be going near this guy because she's so desiring of that HYTA deal that I think we can just trust that she's going to be okay and follow all court orders without having a device on her ankle.
So for traveling for work, is she moving there or is she just going and coming back?
I believe it's just temporary. Is that correct, Ms. Hernandez?
Yeah, just going and coming back.
Mr. Hartung, your position, please.
Mayor, I don't have an objection to either one of the requests. I would indicate to the court that Ms. Hernandez has shown up for court every single time before myself and her attorney is.
Okay. And she was here bright and early this morning. All right, so I will remove the tether. So ma'am, we'll do the order today and you'll need to go to the company that installed it, get that removed. We will change her bond to allow her to travel to Ohio and Texas. Hold on, I gotta make good notes. And you probably need to call Mr. Coast, Ms. Hernandez, and let him know so he can make arrangements and tell you what to do on the tether. Mr. Kavajian, do you wish to go in the breakout room with her in the Michigan Department of Corrections?
I'm happy to do so, sure.
Okay, so I'm gonna put you in that breakout room with Mr. Jones, and we will see you back then on September 5 at 8:15 in the morning. Go ahead and join that breakout room. Thank you.
Thank you
Thank
so
you.
much, Judge.
Thank you.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.